Greetings, hello and welcome to this lecture on the historical development of the UK Constitution. Now the purpose of this lecture is to basically give you a greater understanding of how and why the UK Constitution came to be as it is, as well as a deeper grasp of what it actually contains, by looking at some of the key moments in history when the Constitution was built up. For my students, if you're in my class, I want you to make obviously if you're not, do whatever you want, but if you are, I'd like to make a timeline as you are watching. Just basically note the date of any key events along with the constitutional changes that those events brought about and anything about the significance of those events and those changes. So don't worry about the detail. I'm going to give you quite a few details, but this is really just to try to build up a picture of events in your head. You don't need to write these all down. Just stick to dates of key events, acts of parliament, court rulings, etc. What constitutional changes they brought about and the significance of these. Okay, so by way of introduction, let's just consider, because the UK Constitution is unusual, right? We know that. Most constitutions were created, literally a bunch of people sat around in a room creating them. They were consciously written often on a particular date. They may have been subsequently amended, but they often have a sort of foundational document that was a bunch of people sat down consciously wrote. And this was often when a new state was being created. So for example, the so-called founding fathers who wrote the US Constitution did so when they just overthrown the British Empire and established the US as an independent state from Britain. And then they were faced with the task of creating their own state and institutions from scratch. So they had to figure out, well, what institution we're going to have, what powers they're going to have, how they're going to relate to each other, etc. And it's the same for most countries in the world, in fact. For example, when most African and Asian states, modern states were created when they overthrew their European colonial rulers after the Second World War. And they found themselves in the position of, again, having to establish a new state based on new principles, new rules of government from scratch. And even in Europe, many of the European states had either been taken over by the Nazis during the Second World War or by the Soviet Union subsequently. So when those empires were overthrown, these European states too had to create new constitutions from scratch. But Britain's never been either colonized or occupied in modern times. And so it's never really been in the position of having to kind of sit down and think of a new set of governing procedures and state institutions from scratch. Rather, the UK Constitution, that is the rules and procedures involved in the governing of the country, have emerged and developed over time. The result is, as you know, an uncodified constitution in which the rules over the powers of different state institutions, how they work and so on, how they relate, they all come from various different sources rather than from one single authoritative document. And indeed, most of the current UK Constitution existed before there even was a UK. Much of it existed before there was a Great Britain, and some of it existed even before there was an England. So let's begin at the beginning and start there. England was born almost 1100 years ago in the year 927 when Aethelstan, the grandson of Alfred the Great, conquered the then Viking kingdom of York. And for the first time, the land we now call England was governed as one single independent political unit. And this new state inherited certain legal principles from the Saxon kingdoms that had preceded it, that are now considered part of our constitution and our constitutional rights. Things like trial by jury and habeas corpus, the right to freedom from arbitrary arrest. Then in 1066, as I'm sure you know, you had the Norman invasion of England, the Norman conquest under William the Conqueror. And for the next century and a half, Britain was ruled as pretty much an absolute monarchy, which means basically the monarchy had unlimited power. There was no constitution, really, no rules on how that power could be used. The monarch could simply do as they pleased to whoever they wanted. However, one important element of our modern constitution did emerge in this time. Because the Norman kings also ruled large parts of France, they were often away from England. And so they would appoint judges, known as justices of the peace, to preside over court hearings and dispense justice on their behalf. So this marked the beginnings of the English legal system and the common law. And many of the common law principles that are part of the UK Constitution today have their origins in this period. But the first major challenge to royal power came in 1215 with the signing of the Magna Carta. So you know the story, the barons, basically the most powerful people in the country after the king, his regional deputies, if you like, were getting fed up with their king, King John, mainly due to the arbitrary taxes he kept demanding of them for the wars that he kept losing. So, as you know, they kidnapped him, rode him to an island on the Thames, Runnymede, where they forced him to sign the Magna Carta, a document that set out for the first time in England in written official form key rights that are now considered part of the UK Constitution, codifying, if you like, the old Saxon rights of habeas corpus and the right to a trial, as well as adding some new ones such as limits on taxation and preventing royal interference in the affairs of the church, and also establishing something called the Council of Barons, who had to be consulted on all new legislation. Now, pause the video at this point and just think, what part of our current political system and state institutions do you think had its root in the Council of Barons? That is a body of noblemen who had to be consulted on new laws. Okay, pause the video, think. Okay, did you get it? That's right, Parliament, and more precisely the House of Lords. Back then, the king did not require their consent for new legislation, but Magna Carta established the principle that he had to consult with the lords, with the barons, and it set the stage for the parliament we have now. Far more powerful now, of course, than it was back then. So that was the real significance of the Magna Carta, that it set the stage both for the parliament we have today and some of the rights that we have today. I would just add a couple of caveats here before we get too carried away with the Magna Carta. First of all, the rights it established only applied to so-called freemen, and the vast majority of the country in 1215 were not free. Of course, it only applied to free men, so straight away half the population, women, were excluded. But even of the men, the majority of them were not free men. Around 10% of English people were slaves, and around 2/3 of the rest were so-called villeins or serfs, unfree peasants tied to the land, whose lives were basically under the control of whichever baron ruled their particular area. So actually the rights that were established in Magna Carta only applied to quite a small minority, elite, if you like, of people. A second caveat I would say, and again, just for my student, you don't need to write these down. This is just to aid your overall understanding. Second caveat I would add, that the Magna Carta was basically disowned by King John almost as soon as the barons let him go. He basically ignored it. So although it established certain principles and rights, these were not actually necessarily upheld or enforced on a systematic basis for many years to come. Although I should add, they did provide a kind of point of unity for certain kind of struggles against royal power. There was a unifying document around which struggles could be fought. But it certainly wasn't enforced systematically for many years. Third point, I would say, was made in a lecture by the rapper and author Akala on the Magna Carta, which I attended at Brookes University a few years ago. Very good lecture he gave. He pointed out Magna Carta was just one part of a kind of global body of literature which attempted to codify and give the power of law to people striving for justice and freedom. Akala gives the examples such as the Code of Hammurabi, the Babylonian ruler in 1754 BC, long time before Magna Carta, which instituted legal principles such as the presumption of innocence, the provision of evidence at trials, and so on. And he also refers to the Iroquois Federation in North America, who had their own Grand Council of 50 sachems, chief, twice the number as there were in King John's Council of Barons. And I think this is an important point, given how some nationalist politicians in Britain have attempted to use the Magna Carta in recent years as evidence of some kind of uniquely British commitment to freedom, neglecting the fact that the principles it established were very limited in terms of who they applied to, largely ignored often by many rulers, and were actually far from unique to this country. Despite all that, whilst we recognise its limitations, 1215 is a significant moment in British history, marking the beginnings of some attempt in this country at constitutional government, that is, government that's bound by rules and is not solely at the mercy of the whims of the monarch of the day. So, 1265, exactly 50 years later, the barons rebelled against the king again, and power was actually seized by their leader, Simon de Montfort, leader of the rebels in the Battle of Lewes. To shore up his power, he summoned 2 representatives from each shire and 2 from each town so that he could hear their concerns and win their support. So it was a kind of tactic of being able to, hear what their concerns and opinions were, all different parts of the country, so that he could bring them on board. Now, because the town officials and knights who made up this new body were not of noble blood, they were known as commoners, and this new body became known as, pause the video and have a guess. That's right, the House of Commons. And later kings, such as Edward I, 10 years later, also began to call on this body de Montfort had kind of first established to support their tax demands, sometimes as a counterbalance to the Lords, the Council of Barons. So now you had these 2 groups, the Lords and the Commons, who would regularly go to the King's Palace at Westminster to parley, which means to talk, and so Westminster Hall became known as Parliament, the place of talking, literally. And this is where both bodies, Lords and Commons, could come to air their grievances, that is to let the king know of whatever problems concerned them, and could discuss his requests for taxation. And these are still 2 important functions of Parliament today, right, where ordinary people can go to their MP, their representative, and ask them to air their grievances to the executive, to the government, in Parliament. So you can see how over the course of the 13th century, the 1200s, more limits were being established on the monarch's power, and formal bodies such as the House of Lords and House of Commons were established, which could start to demand reforms in exchange for their support for the monarch's taxation requests. But these bodies were still consultative. They could not actually impose their will on the monarch. And that really began to change, arguably, with a momentous event in 1327. So in 1327, the king, King Edward II, had infuriated the barons. He'd ignored their advice, overturned their reforms. He insisted on appointing advisors that they despised, and he kept waging expensive wars that he then lost, most notably the Battle of Bannockburn against Scotland in 1314. He lost out to Robert the Bruce. And then failing to repel a French invasion in 1326. So the following year, Parliament, fed up of being constantly ignored by Edward, decided that they would get rid of him, arguing that his military and tactical blunders made him unfit to rule on the grounds of incompetence. They demanded his resignation. Fearing that his whole family might be overthrown should he refuse, he duly abdicated, handing over the crown to his 14-year-old son. This established the principle that the executive, which was then the monarch, was answerable to Parliament and could be potentially even removed by them. And again, that's a principle still exists to this day. The executive can be removed by a vote in Parliament. In 1533, the next major step came towards what's known today as parliamentary sovereignty during the reign of Henry VIII. Just pause the video here and recap what you know already about Henry VIII. Okay, so probably you know that he had 6 wives, but politically perhaps one of, or perhaps the most significant thing he did was the establishment of the Church of England. This is when King Henry broke with the Catholic Church, that is, broke the English branch of the church off from Rome and from the Pope, and established himself as head of the English Church. Why this is so important constitutionally is that Henry justified his actions by use of Acts of Parliament. He claimed that because the break with Rome had been approved by Parliament, that showed he was following the will of the people, and that decision should therefore be respected. Now, this was a significant move in the development of parliamentary sovereignty, as it suggested that Parliament had the power to approve the actions of the king, and potentially, therefore, the implication was potentially also to veto them. This became very important a century later in the English Civil War. So in 1642, war broke out between supporters of the king, Charles I, and supporters of Parliament, which was then under the military leadership of Oliver Cromwell. The dispute was over whether the king had the right to rule the country just however he pleased, as Charles I himself believed, or whether he had to consult Parliament. The king lost the war and was put on trial in Westminster Hall in Parliament. He was found guilty and beheaded in 1649, after which the monarchy itself was abolished. Parliament was now by default the supreme power in the land. After the death of Oliver Cromwell, however, Parliament restored the monarchy and asked Charles I's son, Charles II, to be king. Under his rule, which lasted a quarter of a century, the balance of power between king and Parliament was never really put to the test, as they had few major disputes. In 1685, however, following the death of Charles II, his brother James came to power and attempted to reassert royal power over Parliament. This didn't go well for him. Parliament invited the Dutch king, William of Orange, to invade the country and overthrow him, which he duly did. In 1688, in what became known as the Glorious Revolution. Parliament then presented William of Orange with the Bill of Rights, which put parliamentary sovereignty on the statute books for the first time. Essentially, Parliament offered William a deal. You can be king so long as you accept that we are really in charge. Thus, it is the 1689 Bill of Rights that really confirms parliamentary sovereignty as a legally enshrined constitutional principle for the first time. From then on, it would be illegal, even for the king, to pass or remove laws, or to raise taxes, or to raise an army without Parliament's consent. Citizens' rights were established as well. Cruel and unusual punishments, for example, were made illegal by the Bill of Rights. So the Bill of Rights was a very important piece of statute law. Really, it's the closest thing the UK has to a written constitution. And while we correctly refer to the UK constitution as a whole as uncodified, there are certainly parts of it, the Bill of Rights first and foremost, which are codified. So, although it's not part of the specification, it's nevertheless interesting to consider how did Parliament get so powerful in the centuries leading up to the Glorious Revolution. I will not attempt to give a comprehensive answer here, and it's no need for you to particularly make notes on this unless for your own interest you want to. It's not something that's going to come up in the exams. But I think it's interesting to consider, isn't it, how you went from Britain basically being an absolute monarchy in the years after the Norman invasion. The king could do just whatever they wanted, to actually here you have Parliament actually establishing power even over the monarch in 1689. So how did that happen? How did Parliament become so powerful? I won't attempt to give a comprehensive answer here, but I would just draw your attention to two important factors. One was the constant wars in which English kings seemed to embroil themselves, primarily of France and Scotland. The more the king went to war, the more he needed money, and the more money he needed from his barons, knights and townsfolk, the more leverage this gave them over him. They could slowly begin to put conditions on their financing of his wars and debts. It's relevant here that several of the key moments in constitutional development, the signing of the Magna Carta in 1215 and the forced abdication of Edward II in 1327 being prime examples, were preceded by disastrous military defeats. Second was the development of a merchant trading class, boosted by colonialism. In times of feudalism, when England was basically an agricultural economy, the wealthy elites were landowners whose wealth was based on rent. But the landowner-in-chief was the king, and all the smaller landlords were basically beholden to him, dependent on him for their lands and positions. So this gave him a great deal of control over them. But from around the 15th century onwards, a new class of wealthy merchant traders began to emerge, whose wealth was more independent of the monarch, and their wealth came not from collecting rent from their tenants so much as from the profits of production and trade. As Britain became an overseas empire, colonizing lands in the Americas, the Caribbean, later Asia and then Africa, these merchants were able to enrich themselves through colonial trade and, let's not forget, plunder. This increased their power enough to challenge the old ruling classes of landowners, noblemen, and ultimately even the king himself in the Civil War, 1640s. And Parliament became the voice of this new merchant elite, and in many ways their struggle against the king in both the Civil War of the 1640s and the Glorious Revolution of 1688 were about their opposition to the king's attempts to limit their trading opportunities. With this in mind, it's worth considering also some of the negative consequences of the Glorious Revolution. I'm going to spend a bit of time on this. Like I say, you needn't make detailed notes on this, but it is such a, like I say, it's 1689 Bill of Rights, which was the document of the Glorious Revolution that laid out the changes that it had wrought. This is really perhaps the most significant part of the UK Constitution. Like I said, the closest thing we have to a codified constitution. So I'm going to spend a little time on it. But I think it would be remiss not to point out also some of the negative consequences of the Glorious Revolution, which along with parliamentary sovereignty also established this new merchant class as basically the new ruling class of England. And one immediate consequence of the Glorious Revolution, for example, was the massive increase in the transatlantic slave trade. Something that's never mentioned in your textbooks when they look at this, but very important to consider. The transatlantic slave trade, the kidnapping and sale of Africans to provide forced labour on the sugar and tobacco plantations in the European colonies in the Americas. Before the so-called Glorious Revolution, there was only one company in England which was allowed to involve itself in the slave trade, as it had what was called a royal charter allowing it to do so, the Royal African Company. And this had particularly angered the sugar and tobacco merchants, plantation owners in the Americas, who believed it limited the growth of their industries as it limited the number of enslaved Africans available to them. They wanted the deregulation of the slave trade, so that more companies could involve themselves in it and more slaves could be captured and shipped. Thus, these colonial merchants were major financiers of the Glorious Revolution, and they got what they wanted. After 1688, the trade was indeed deregulated, and the slave trade grew massively over the century that followed, devouring the lives of millions and setting in train an economic and demographic disaster from which Africa has still not recovered to this day. That is why, whilst British historians refer to the events of 1688 as a glorious revolution, the African-American historian Gerald Horne, for example, says that for his people, 1688 represented, quote, the dawn of the apocalypse, opening the door to what can only be described as a genocide. It's worth bearing in mind, as it's never mentioned anywhere in your textbook, that one of the main freedoms for which the glorious revolutionaries were fighting was the freedom to enslave. To return, however, to the parochial confines of Michael Gove's A-level curriculum, it's worth briefly mentioning that not all of the monarch's powers now went to Parliament, and he retained significant power to act without parliamentary consent in the field of war and foreign policy. For example, signing treaties with foreign rulers and going to war. Pause the video here and remind yourself what's the name of those powers that today are generally exercised by the Prime Minister, those powers that can be used without parliamentary consent. Did you remember? That's right, the royal prerogative powers. Another important moment in the development of the Constitution came in 1701 with the Act of Settlement. This came about due to the problem of royal succession, that is, who would be next in line to the throne after the death of William of Orange and his wife Mary, who ruled as joint monarchs after 1688. The immediate successor was no problem. That would be Anne, a sister of Queen Mary, but neither Mary nor Anne had any children. This meant that the crown was due to revert to one of the heirs of either James II or Charles I, both who had been overthrown by Parliament and whose heirs were Catholics and therefore completely unacceptable to the staunchly Protestant Parliament. Thus, the Act of Settlement was passed to overrule the traditional royal bloodline, decreeing instead that Queen Anne's heir would be George of Hanover. He would be the next king after she died. He was actually only 50th in line to the throne by royal blood. He'd never been to England and didn't speak a word of English. But he was chosen because he was the closest in line who was not a Catholic. And Catholics at this time, apart from being the religious enemy, were seen as allies of France and Spain, England's major colonial rivals, whom the Protestant merchant traders sought to displace from their lucrative colonies in the Americas and the Caribbean. So, when George of Hanover became King George I on Anne's death in 1714, this was the result of an act of Parliament, not due to the traditional bloodline rules of inheritance, and thus was another major consolidation of parliamentary sovereignty, establishing that statute law could now supersede even the most time-honoured and sacrosanct royal traditions. But the 1701 Act of Settlement also firmed up parliamentary sovereignty in a number of other ways as well. It established, for example, that judges could not be removed without the consent of Parliament, that royal pardons could not be granted to anyone who'd been impeached by Parliament, and that the monarch could not launch a war to defend their home country without the consent of Parliament. There were also some discriminatory aspects to the Act, establishing, for example, that the monarch could never be a Catholic nor married to a Catholic. And finally, the Act also established the principle that the monarch could only appoint ministers who could command a majority in both houses of Parliament. And this greatly limited the king's power of appointment over ministers, over members of the executive, as he could no longer simply appoint his favourites if they did not have the support of Parliament. Another important constitutional development, remember, because it is the monarch who appoints the Prime Minister, right? It's still the case to this day. Another important constitutional development came in 1707 with the Acts of Union, which created the United Kingdom. Most of Wales had already been under English control since its conquest by Edward I in the 1270s, and the King of England had also been the King of Ireland since the reign of Henry VIII in the 16th century. Scotland and England had been ruled by the same king since 1603, when the Scottish King, James VI, inherited the English crown. But until 1707, Scotland still had its own separate parliament and was therefore governed by different laws, as also was Ireland. But in 1707, Scotland was effectively forced into dissolving its own parliament and subjecting itself to rule by Westminster. It had, over the previous decades, embarked on a disastrous colonial venture in Panama, which had virtually bankrupted the country, and England took advantage of its predicament by threatening an economic blockade that would ruin the country unless it closed its parliament and subjected itself to rule by Westminster. Thus was the new country of Great Britain established. The reason we talk about the Acts of Union, plural, is that both at this date, 1707, is that both the Scottish Parliament and the British Parliament passed these acts. The Scottish Parliament passing an act to dissolve itself, and the British Parliament incorporating Scotland under its jurisdiction and adding several dozen new Scottish constituencies. In 1765, a landmark legal case, so this is quite long, by the way, this lecture, it's quite long, so if you want to take a break in the middle is probably a good idea. If your concentration starts flagging, because it's all good stuff, you don't want to miss anything. In 1765, a landmark legal case known as Entick versus Carrington took place. John Entick was a writer, infamous at the time for his no-holds-barred attacks on the government in his articles, which obviously the government didn't appreciate. In response, the government sent 4 men, led by Nathan Carrington, to his home, basically to teach him a lesson. The men broke down the door, trashed the place, and made off with hundreds of books, pamphlets, and bits of writing equipment. The damage was estimated at £2,000, which equates to nearly $500,000 in today's terms. Well, Entick was not having it, and he took Carrington to court. The court eventually ruled in Entick's favour, and the government were forced to pay damages to Entick and return the items they'd seized. The judges argued that while ordinary citizens could do anything they pleased, unless it was explicitly forbidden by law, for the executive, that is for the government, it was exactly the other way around. Government ministers, in their official capacity, could do nothing unless there was a specific law giving them the power to do so. And since there was no law expressly allowing ministers to order other people's homes to be smashed up and their stuff stolen, Carrington and those who gave him his orders had been acting unlawfully. So this ruling is a crucial piece of common law in the UK Constitution, helping to develop the principle of the rule of law. Just pause the video here and remind yourself what the rule of law means. That's right. It means that everyone is equal under the law. Basically, that both nobody is above the law and that nobody can be punished unless they've broken the law. No punishment without crime, if you like, and no crime without punishment. By doing what they had done to Entick, Carrington and his men had violated both these principles. For Entick was being punished despite having committed no crime, whilst Carrington was effectively carrying out a crime, burglary, expecting not to be punished for it due to the fact that he was working on government orders. So this is a good example of a piece of common law, a judicial ruling, that forms part of the UK Constitution and crucial to the rights we have today. Now, back to statute law. In 1801, a further Act of Union was then passed when the Irish Parliament was closed down and Ireland, which was already a colony of Great Britain, was forcibly incorporated into the British state, creating the United Kingdom of Great Britain and Ireland. Although the vast majority of Irish people were Catholic, all 100 of the new Irish MPs had to be members of the Church of England. Catholics were also banned from attending university, becoming teachers, joining the civil service and many other professions. Eventually, after years of insurrection, the Irish forced British rule out of the majority of their country in 1921, creating the new independent state of Ireland. But Britain still hung on to what was then the most profitable, industrialised and Protestant-dominated part of the country in the north of Ireland, which remains part of the UK today. But remember, the constitution can be changed not only through the introduction of new acts of parliament or by judicial rulings, but also by simply establishing a new convention. One such convention, known as King's Consent, was introduced in 1721. This convention requires that any bill that affects the monarch's private property must first gain the consent of the monarch before it can be put to Parliament. This convention is thus quite a reversal of the newly established parliamentary sovereignty, and shows that constitutional developments have not all been in a single straight line towards democracy and parliamentary power, as King's Consent allows the monarch in effect to veto certain bills before they can even be debated in Parliament. Queen's Consent, as it's known today, has been sought at least 150 times since 1970, one recent example being the 2006 Animal Welfare Bill, which required the King's permission to go before Parliament, as it allowed animal welfare inspectors access to private estates to investigate claims of animal cruelty. Because this therefore affected the Queen's private estates, it required her permission. To ensure the Queen did not veto the bill, her private estates were actually given an exemption from the bill. Unique. Only person in the country had to have an exemption from this bill. Undermining the rule of law, you might think. This law at least doesn't apply equally to all. Queen's Consent was then extended to her oldest son in 1848, so now any bill that affects the private interests of the Prince of Wales require his personal consent also. The final constitutional reforms that we'll look at in this lecture are the Parliament Acts of 1911 and 1949. Up until 1911, the House of Commons and the House of Lords both had what is known as veto powers. Because the consent of both houses was required for any proposed legislation to become law, this meant that either house could veto or block a bill from becoming law. However, by the early 20th century, as Britain finally entered the era of modern democracy, the idea that unelected lords, most of whom had simply inherited their positions from their fathers, could block the legislative agenda of the elected House of Commons seemed more and more untenable. This came to a head in the battle over the 1909 so-called People's Budget, which was set to introduce a raft of welfare relief measures for the masses, such as the first ever old age pensions and unemployment benefit, to be funded by increased taxes on the wealthy. It was passed in the Commons by a large majority, but blocked by the House of Lords, which was of course dominated by the wealthy elites whom the budget proposed to tax. The Liberal government held an election on the issue and won with an increased majority. The Lords then grudgingly passed the budget, but to prevent any future attempts by the Lords to block the plans of the elected government, the Prime Minister Herbert Asquith put forward a bill that ended the Lords' power of veto and instead gave them the power only to delay a bill by 2 years if they rejected it, after which the Commons could overrule them and send their bill to the monarch for royal assent despite the Lords' objections. The 1911 Act also gave the House of Commons exclusive power over money bills, meaning that from then on, budgets did not require the approval of the Lords at all. The 1949 Parliament Act then reduced the Lords' delaying power from 2 years to 1 year. The Parliament Act's chief significance, then, is their weakening of the power of the House of Lords, establishing the primacy of the House of Commons within Parliament. So, I hope then that this lecture has given you more of an understanding of the history of the UK Constitution how some of its key principles were established. We've seen, for example, how the rule of law, which had its roots in the Saxon legal principles of around 1,000 years ago, was developed both through parliamentary statute, for example in the Bill of Rights, and through common law in, for example, the Entick versus Carrington ruling in 1765. And how parliamentary sovereignty had its origins in Henry VIII's break with Rome and was subsequently consolidated in the Bill of Rights that followed the so-called Glorious Revolution. However, I do not want you to think that this was a peaceful, gradual and inevitable process. Rather, if you consider the key moments in this history, you can see that it's often during periods of intense conflict between different sections of the ruling elites, which often involve one or other section mobilizing the masses to their cause, that we see the greatest changes occur, as threatened monarchs make concessions to shore up their power, or contenders impose limits on the monarch's power in order to advance their own. History is not an unbroken march of progress, but moves in fits and starts, with many reversals and defeats along the way. We've seen in recent years the rule being undermined by, for example, the failure to hold police officers to account over deaths in custody, or by the failure to bring prosecutions against those who illegally covered Grenfell Tower in highly flammable cladding, resulting in the deaths of over 70 people. The other trend I would like to emphasize is the struggle not so much for more rights, but to extend existing rights to classes or groups from whom they had been withheld. For example, as we've seen, the right to a prompt trial existed already in Saxon times, but only applied back then to nobles. Many centuries of struggle led to its extension to ordinary citizens, but even in our lifetimes, battles have had to be fought for these rights. For example, in 2001, Parliament enacted legislation that allowed for the indefinite detention of foreign terror suspects without charge, leading to around a dozen people being incarcerated for years on end without ever having been told what they were charged with or what the evidence against them was, let alone being put on trial. It was only in 2004 in the Belmarsh case that the judges ruled that such detention breached the Human Rights Act, and the legislation was subsequently amended and those imprisoned released. However, even then, new struggles were fought against the so-called control orders, basically a form of house arrest that replaced imprisonment for those released. And it is precisely the ease with which the executive seems to be able to override long-held constitutional rights simply by introducing new legislation or by ignoring conventions that's led many to argue that a codification of the Constitution is necessary to prevent the abuse of power by the executive. This will be the subject of our next lecture. Thanks for listening. Bye-bye.